So, welcome again to Criminal Law 1, Constitutional Criminal Procedure. Today's topic is arrests. Before we jump into arrests, let's review our last lecture. So, if you recall, our last lecture we discussed Terry stops, also known as stop and frisks. Terry stops generally are limited to intrusions that are meant to detect and investigate crime. So during a Terry stop, you're not free to leave, but these detentions do fall short of an arrest. So instead of having to have probable cause to effectuate an arrest, which we'll get into today, generally speaking, you only need 50.01% sure that, or excuse me, 10 to 15% sure that somebody is engaging in criminal activity or is about to engage in criminal activity, right? So you only need reasonable suspicion. So reasonable suspicion is some kind of articulable suspicion. Right, something that a reasonable person would say, yeah, that's suspicious, right? You don't have to have certainty. You don't even have to have more likely than not, just enough to raise a little bit of a question. Now, that being said, when we're talking about Terry stops, they can be considered unreasonable. Now, if they're considered unreasonable, this triggers the Fourth Amendment and the exclusionary rule, right? So Terry stops can be challenged for any factor making them unreasonable under, and this is our key term, totality of the circumstances, right? So everything that the officer knew at the time, everything the officer witnessed and experienced at the time. These circumstances can include movement of the detainee during the stop, right? So we discussed that you can move somebody during a Terry stop just a very short distance, just basically out of the way of people. But we discussed how moving somebody to 40 feet to an office was considered de facto unreasonable, right? We also look at the length of detention. Length of the detention is a little bit tricky. It's a little bit more subjective. Generally speaking, the longer the detention lasts, the more we're going to say it looks like an arrest. And if you don't have probable cause to make the arrest, you're just trying to do a Terry stop with an articulable suspicion, then it's going to be unreasonable. Now, length of detention really depends on a number of factors, including what the crime is that is being suspected, as well as police resources. All right, so we saw one case where we had the suspect had to wait at LaGuardia Airport for like 45 minutes for a dog, a drug-sniffing dog, to come to the airport. Police said that that was unreasonable, right? It's LaGuardia Airport. They have them everywhere. Like, why did they have to wait? On the other hand, police pulled a Terry stop on a vehicle and waited until backup arrived, right, before proceeding with the rest of what they were doing. Now, backup took about 30 minutes to get there. And in this case, we said that it was reasonable because there was no detours, no stops in the terms of the backup responding, right? The backup came immediately. So again, it's very subjective, but again, the longer that you're detaining someone, the longer it's going to look like an arrest and require probable cause as opposed to reasonable suspicion. And then we look at the intrusiveness or the techniques deployed during the stop, right? So the more intrusive a stop is, right, especially if we're talking about the frisk component, generally speaking, we're going to say that it's unreasonable, right? So frisk are supposed to be limited to the outer clothing and for the purpose of detecting weapons. Now, plain field doctrine does apply, and if during the stop the officer's patting down the clothing and feels a weapon or they feel something they know is contraband like drugs, then they can reach inside the detainee's pockets, pull it out, or their waistband, pull it out wherever they have searched. And again, this idea is for safety and just to see what's going on as opposed to making an arrest. The more intrusive we get, the worse it becomes. And we've looked at some various cases that have dealt with just how intrusive can we be during Terry stops. And if you recall, the answer is not very, right? The answer is not very. But keep in mind, you can do Terry stops on more than just a person. Right? You can Terry stop a vehicle. You can frisk a vehicle, right? So you can just pat it down more or less on the inside for weapons, and anything that you find during the frisk, if you have reasonable suspicion, can come into evidence against you, right? So Terry stops, they're an interesting weapon in law enforcement's arsenal because they do fall short of requiring probable cause. They're not an arrest, but you're not free to leave. So it's not just an encounter. This is the weird kind of middle ground that a lot of court opinions appear to be subjective on in terms of movement, length, and intrusiveness. So that being said, let's jump into talking about today's subject, arrest warrants and probable cause. So just like searches, we have a preference that arrests be made pursuant to a warrant. All right, so if you recall, the warrant requirement of the Fourth Amendment says that you should be free from unreasonable search and seizure, right? Absent a warrant made with a finding of probable cause. Now, there are exceptions to the warrant requirement, right? And we've discussed those in great detail. But generally speaking, and if you recall, if we search somewhere without a warrant, it is de facto unreasonable. And upon the defendant's challenge, the prosecution has to prove that one of the exceptions for a warrantless search applied. Now, if we take that same reasoning and we put it towards arrests, we have the same preference, right? So we prefer it to be done pursuant to a warrant. Now, the warrant, just like in searches, has to be issued by a neutral decision maker and upon support by oath or affirmation. So we still have this neutral decision maker, oath or affirmation, and what we're going to see is that arrest warrants will issue upon a finding of probable cause. And we've discussed probable cause 50.01%, 51%, 50% in the feather, however you want to conceptualize it. Now, there are two requirements that we have to have probable cause for, right? So we have two separate probable cause analyses that we have to do when we are getting an arrest warrant. Right? So there must be a fair probability, right, greater than 50%, that one, a crime has been committed. So officers who are seeking an arrest warrant have to show by 50.01% that a crime has been committed, right, to the neutral fact finder, the neutral decision maker. And two, law enforcement also has to demonstrate that the person named in the arrest warrant committed the crime. Again, this is by a finding of probable cause, right? So we have to find probable cause on both of these elements in order for an arrest warrant to issue. If we fail to meet any of these two requirements, then officers cannot make the arrest with some exceptions, and we'll talk about that. And generally speaking, judges can't issue a warrant, right? If you didn't prove to me that there was a crime committed, you just said that the person committed a crime. No, we're going to need something more than that, right? But again, this is supported by oath or affirmation. And just like search warrants, judges tend to be very lenient when it comes to issuing warrants. They kind of issue them almost like candy, but they run the risk of having evidence suppressed. We'll talk about that in a minute. That being said, while we do have a preference for warrants or warranted arrests, depending on the circumstances, arrests can still be made without a warrant. If we make an arrest without a warrant, and we're going to look at the circumstances in which we can, generally, what we're going to require is called a Gerstein hearing, otherwise known as a probable cause hearing, within 48 hours of the person's arrest, right? So the idea here is if we make an arrest without a warrant, and we'll discuss some of the exceptions in a moment, we have 48 hours to bring that person before a judge to demonstrate to the judge that a crime has been committed and that this person committed the crime, again, by probable cause. Now, usually this is the upper end of a Gerstein hearing. Generally speaking, you're supposed to be brought before a judge without, quote, delay or due delay. So theoretically, you should see a judge as soon as practical after you are arrested. But 48 hours, we say, is the limit, right? When we say it's the limit, we mean it's the maximum length of detention possible without formal charges being brought, right? So if you don't go to a judge, right, in 48 hours, you have to release that person. Doesn't mean you can't arrest them again, but judges are going to get really suspicious and really angry that you did not bring them to them. Now, bigger cities, so for instance, New York City, they have what's called night court, and it's what it sounds like. It's court that takes place at night, right? So New York City courts almost function 24/7. And the idea is you can arrest somebody, bring them immediately to a judge so you don't run afoul of the Fourth Amendment and you don't run afoul of our required Gerstein hearings. Now, keep in mind, if you are a law enforcement officer, you now have something to play with. You have 48 hours, right? So theoretically, if you wanted to hold somebody for a period of time so that you could investigate without them tampering with evidence or without them fleeing for the country or whatever, you could theoretically arrest them, hold them for 48 hours, and then just release them, right? So you buy yourself some time. Now, judges really don't like that, right? Because you're taking somebody's liberty away without probable cause, without reason, to make your job a little bit easier. That doesn't fly well normally. So keeping that in mind, it is a tool for law enforcement, but one that is looked down upon. Now, when we're talking felony arrests, right? So remember, we always have the preference for a warrant. That being said, warrants are not required to make felony arrests in public. Right? So if somebody is in public and they have committed a felony, or you have probable cause to believe that they have committed a felony, you can make an arrest in public. This gets different when we talk about outside of public, but in public, if you have probable cause, you can make an arrest, right? And the trade-off here is felonies are usually severe, right? They are usually dangerous, and we're balancing, right, individual liberties against security interests. And if you have probable cause, 50% and a feather, to believe that somebody has committed a felony, you can effectuate the arrest with the idea being, look, it's probably dangerous. If it turns out there's not probable cause, you'll get released within 48 hours, if not sooner. So it's minimally intrusive. Now this changes when we talk about misdemeanors. So generally speaking, if police officers want to make an arrest for a misdemeanor, what really matters is if the crime was committed in the presence of the officer, right? So an officer can make an arrest in public if the crime was committed in the presence of the officer, if the officer witnessed the crime. Now, if the officer didn't witness the crime, but has probable cause to believe the crime occurred, they cannot make an arrest, right? They have to go get a warrant. Now, that raises kind of a question of how many people really go get warrants for misdemeanors, especially low-level misdemeanors. It just, honestly, it depends. But there's obviously a kind of a deterrent value there. And again, we're judging security versus personal liberties, right? Whereas felonies are severe, and if we make a mistake, you'll get out in 48 hours or less. Misdemeanors are generally not that severe, right? If you take a felony and you go all the way to trial, or you go to a certain point, you're probably just going to get probation, right? And officers know this, so why waste their time? So again, for felonies, you can make an arrest in public if you see it, or if you have probable cause to believe it occurred. For misdemeanors, you can only make an arrest if you see it, not if there's probable cause. If you didn't see it, but you have probable cause, get a hold of the judge, right? And that's what we kind of talk about in the Atwater case. Now, that being said, what about when we're not in public? Well, felony arrests that occur inside the home, right, generally require a warrant unless exigent circumstances are present. Right, so this is not public, we're at home. So one of the seminal cases on point is Peyton v. New York. So in this case, New York City police officers had suspected Peyton of murdering a gas station manager. The police forcibly entered Peyton's home, thinking he was there. Well, as it turns out, he wasn't. And while they were in the home, they found evidence connecting Peyton to the crime. This was introduced at trial, but the problem here is police lacked an arrest warrant when they entered his home. So they didn't have a search warrant, they didn't have an arrest warrant. They were acting under a New York law. The New York law allowed police officers to enter private residence to make felony arrests without a warrant. Now, at trial, Peyton tried unsuccessfully to get the evidence suppressed. He was convicted, and it works its way up to the Supreme Court. The Supreme Court is tasked with answering the question, is this New York statute, which allows officers to come into your home to make a felony arrest without a warrant, constitutional? And the justices said no, right? It's not constitutional. The Constitution says, as we've interpreted, that you need to have a warrant. Regardless of what the state says you can do, you need to have a warrant to enter a home to make an arrest. Because if you recall from our discussion on searches and seizures, the home is the most sacrosanct place on earth, at least for judicial purposes, right? It's where you enjoy the most civil liberties, it's where you're the most protected, etc. So if we just allow a state to say, nah, we're not going to follow that, then the home loses all of its protection, right? So again, if we're doing felony arrest, exigent circumstances have to be present if we don't have a warrant. Now, this largely depends on where in the home the police go, or the offender or would-be offender is located. So for instance, if we think about comparing different things, doorways, porches, and common areas, right? If you are standing in your doorway, right, and your doorway, has a threshold like they all do. If you're standing behind the threshold, police are generally going to need a warrant, right? Again, because you're within the home, you're protected. However, when you step outside of the threshold and you jump into when you pass that threshold, you go into public. And that's what we've considered, right? We've considered suspects on their porches. If a suspect is on their porch, are they home or are they in public? And generally we've said it depends on the nature of the porch. If it's like an uncovered porch that doesn't have a door or anything like that, then you are considered to be in public. All right, and officers can make an arrest without a warrant. If, however, your porch is covered, right, and it's kind of like a sun porch where there's a door, well, we're going to consider that part of the home, right, because that's the expectation of privacy. You're thinking, I'm placing myself away from and out of the common areas, or excuse me, out of public view of public places. Police can also search and effectuate arrests in common areas, right? So think about an apartment complex, right, where maybe the apartments are interior, so it's a condo association. And so all the doors are on the inside. Well, police can come in to the common areas and make an arrest of you in the common area, right? Because theoretically you're in public. Yeah, they had to enter the building, but they didn't enter your home, right? They're in the common area. You have no expectation of privacy, generally speaking, in common areas. So what do some police do? They may go undercover, or they may have uniforms on, knowing they can't make an arrest of someone in their home. So they just sit outside on the landing or the stairs or whatever, waiting for the person to exit the threshold. And as soon as that person crosses that threshold, they are in public and no warrant is needed. Now, this is also true of hotel rooms. So just like when we discussed searches and seizures in that context, hotel rooms are considered homes. Right? So if you're in your hotel room, police need to get a warrant. If, however, you cross the threshold of that hotel room door and you are in the hallway, you are no longer in your home. You are in public. right? So just because something is private doesn't mean it's not, it doesn't mean it's a home, right? And generally speaking, we're going to require exigent circumstances. We'll talk about exigent circumstances in a moment, but you're going to see there's kind of a very well delineated line as to what constitutes an exigent circumstance and what does not. That being said, absent content or exigent circumstances, arrest warrants are also required to make arrests in the home of third parties. Right? So that's where you see Stegall. This is kind of an interesting take, right? Because this basically says you are in, let's say you committed a felony, and you know the police are going to look for you at your home. So you decide to go to your friend's home. Your friend lets you in, you tell him all about it, whatever. He lets you crash there, right? The police, generally speaking, if they find out that you're at your friend's home, generally they have to get a warrant to cross that threshold to come get you. Now, it raises a question of whose rights are really being violated here, right? Are your rights as the suspects being violated, or is it the homeowner, the third party? When we look at case law, and if you get like really into the case law like I'm doing, you're going to see that there's kind of a contradiction here, right? And we say that, yes, the third party is really kind of the victim because they've had their constitutional rights trampled on because they were home, but police, in order to enter a home, because it is so sacrosanct, must have a warrant, right? So it also gives a little bit of leeway or a little bit of incentive for defendants to flee, right? Say, well, if they have a warrant, they're in my home, they're going to find me. They don't have a warrant, I'm home. They're going to basically surround the house till they get the warrant. Or you go hide out at a friend's house and they have to get a warrant. They have to find me there and they get a warrant, right? So it's an interesting piece of case law. But again, absent consent or exigent circumstances, arrest warrants are required in the home of third parties. And when I say consent, I mean the homeowner consents, right? Or if maybe you're the wanted person and you answer the door and you say, yeah, you can come in and arrest me, like that's consent too, that's fine. And again, remember the same rules apply for consent searches as they do for consent arrests, I should say. So, what exigent circumstances should we consider? Generally speaking, exigent circumstances are going to be those where the police do not have the time to get a warrant. Right? And what we mean by that is it would be impracticable for the police to get a warrant, or it would put the general safety of the public in danger and of not getting a warrant, right? So one of the first ones we can think of is hot pursuit, right? So you have United States versus Santana. Think of hot pursuit this way. Basically, if the police officers know exactly where a person who is fleeing, let's say you try to initiate a stop in public, and the person takes off running, or maybe they go off in car. As long as they are basically within your view, or as long as you know where they are, you are in what's called hot pursuit, right? The moment you lose track of where they are, unless you find them again, you're no longer in hot pursuit, right? So hot pursuit says, look, if you're making an arrest and this guy runs into some random person's home and slams the door shut, should police really have to get a warrant? I mean, the same thing would be true, and might be a little bit different analysis if it was the defendant's own home. But if they run into a house, and we say houses are so protected, would it make sense for them to say, "Wait, well, we can't go in there. We have to get a warrant." So they have to call the judge, they have to present the probable cause, et cetera, et cetera. Meanwhile, this person could theoretically be holding a gun to somebody's head, killing people, God knows what, right? So we say if the police chase somebody in hot pursuit, they can enter the residence of another or even that person. That being said, recall from search and seizure that once police are inside an area or inside a home, plain view applies. Now, if police go inside a home in search of somebody, they're going to conduct what's called a protective sweep. We discussed that a little bit. All right, now all it is just supposed to be a very quick look around to make sure there's nobody hiding anywhere, right? But if during this protective sweep they find illegal things like narcotics, they can effectuate an arrest. So theoretically, if a wanted person is running from police and they run into your home and you happen to be a cocaine dealer and police see the cocaine, guess what? The guy who ran into your home is getting arrested, and so are you, right? And the idea here is they're in hot pursuit. It's an exception to Fourth Amendment requirement based upon public safety. Right? And public safety brings us to the second one. When we're talking about is it the safety, is it public's best interest, is it safe for them to effectuate an arrest? Now, generally speaking, this includes what's called the emergency aid doctrine, right? So let's say police officers walking a beat, right? And they're walking beside a house. And from the house, they hear a scream, and then they hear help. That police officer does not need to get a warrant to go inside that house. They can kick down the door because the idea is they're rendering emergency aid. Right? If somebody's screaming help, it doesn't make much sense to make us go get a warrant. Now, what becomes interesting is 911 calls. I'll say they become interesting if somebody, let's say, is having a heart attack, right? So each state does things differently. I'm not sure about New York, but Massachusetts or Missouri, if an ambulance was dispatched, a fire truck also was immediately dispatched, right? So if you call 911, my husband is having a heart attack, can you send in help? They send an ambulance. An ambulance is going to show up to your house, and so is a fire truck. My question, and it's a decent question that is a weird line, is what about if a police officer shows up, right? I think it would probably depend upon the timing of the officer's arrival. Because if the paramedics have already arrived, or if the fire truck has already arrived, they have the training to deal with the emergency, and the emergency is being dealt with, so emergency aid might not be necessary. But if an officer hears the call, and they happen to be right in front of the home, and they hear the call that, help, my husband's having a heart attack, they can respond. Right? Because officers are trained in first aid, they're trained in CPR, they're trained in giving response. And I think we as the public would want somebody, even if it was a police officer, to help until professional medical people arrived. So let's say you call 911, my husband's having a heart attack, and an officer comes in, does CPR. While performing CPR, he sees a pile of cocaine on the nightstand. Well, this person, assuming they live, is getting arrested, right? And probably the person they're living with. And again, it's emergency aid. Now, a question also becomes too, and this also extends, remember, that the Fourth Amendment doesn't just deal with law enforcement. The Fourth Amendment says the government. Depending on the state, depending on the circumstances, ambulances tend to be private. Fire departments are not, right? So fire department comes in to assist the EMTs, and they see something, they see what they perceive as cocaine. They can tell the police officer, right? Then the police officer will have to, generally speaking, get an arrest warrant or a search warrant and go from there. So they are still government though, right? And theoretically, they are barred. Police officer or firefighters cannot enter your home without a warrant unless there's exigent circumstances, right? In this case, emergency aid doctrine. That being said, firefighters aren't going to enter your home without there being an emergency. But it's not like the police can send in a firefighter in their stead because, like, oh, we're law enforcement, they're firefighters, we're different. No, the Fourth Amendment protects you from government intrusion. Then we have likely destruction of evidence. This is a Kerr versus California case. And what it does is it includes basically what's called police-created exigency. Right, so let's say the police are chasing somebody, right, and they lose sight of them for a minute. They run into one of two buildings, and they're apartment buildings, and police officers kind of go door-to-door knocking, asking if the person is there. They come to this door, they knock, and they say, this is the police. And suddenly they hear shuffling, scrambling, and what sounds like flushing. Police can come in. They can kick down that door. Because even if you're not necessarily the person they were looking for, you are probably destroying evidence of some crime, right? Even if the police created the exigency, right? So even if you had no intention of destroying your evidence, but the police created it by knocking on your door, it's still an exigent circumstance, right? If we have the likely destruction of evidence. And the drug flushing case, I mean, there's an actual case, drug flushing case, that gets involved here. Yeah, the police can come in, right? Even if it's not necessarily the original crime that they were thinking about. So this is a little bit of a tricky situation, right? Because remember we talked about if you run from police when you see them, you have probably created probable cause and the very least reasonable suspicion that you've committed a crime. But again, this is the white man's standard, right? If you're not white, or if you've been historically victimized by the police based upon race, ethnicity, whatever, things might be different, right? You might turn and run from the police. And so likely destruction of evidence could also be a reason to enter a home and stop the destruction of evidence. Again, police can do this, and it's difficult when you consider that it's, again, the white man's standard, right? But it's true for any ethnicity. Police knock on your door and they don't do the gentle knock and they say police, like you're gonna look, even if you have nothing, you're gonna look around real fast to make sure that you have nothing before you answer that door, right? So police can come in that situation. Now there's a 1998 case that has never really been answered, which is unlikely flight, or excuse me, likely flight, right? So in this case, let's say police suspect that if they have to get a warrant, you will flee the area before they can get that warrant, right? Like you have every intention, you've got your passport, you have everything. You are going to flee the area before they can get a warrant. In this case, at least the Sixth Circuit has said, yes, you can make an arrest without a warrant, right? You can enter the premises of a home or something along those lines without a warrant. It hasn't been firmly settled by the Supreme Court, to my knowledge, but that's an exigent circumstance. That being said, usually we're talking exigent circumstances dealing with felonies, right? Dealing with things that are putting people in danger, because we're balancing danger versus constitutional rights, right? That's why we have hot pursuit, public safety, etc. Right? We say in these cases, we'd rather err on the side of making sure people are safe than err on the side of protecting their constitutional rights. When it comes to minor offenses, right? When it comes to misdemeanors and other, even like really minor felonies, rarely will exigency exist. So there's one case on point, Welsh v. Wisconsin. Just kind of give you a brief overview of Welsh v. Wisconsin. Basically, what's happened is a witness is observing a car as being driven erratically and that eventually swerves off the road, coming to a stop in a field without causing damage to any person or property. Ignoring the witness's suggestion that he wait for assistance in removing his car, the driver walked away from the scene. The police arrived a few minutes later and were told by the witness that the driver was either very inebriated or very sick. After checking the car's registration, the police, without obtaining a warrant, proceeded to the defendant's nearby home. They gained entry into the home and they found the defendant lying naked in bed. He was then arrested for operating a motor vehicle under the influence of an intoxicant, so a DUI. Right? Under the Wisconsin statute, a first offense for a DUI was a non-criminal violation subject to a civil forfeiture proceeding for a maximum fine of $200. Right? This was 1984. So basically, you have a guy who gets arrested for DUIs. Now, that being said, Welsh v. Wisconsin tells us that what the police did was wrong, violated the Constitution, right? And the idea was, okay, it's a warrantless search. You have a nighttime entry to make an arrest for a civil, non-jailable traffic offense, and that should be protected by the Fourth Amendment. So that's the take behind it, right? Is if you're talking non-severe crimes or civil offenses, generally speaking, exigency is not going to exist. It could, right? And it can be situational. So maybe you catch somebody smoking marijuana in a place where it's been decriminalized, it's a civil fine, but they take off as soon as they see you, and you are the officer, you can make an arrest because you witnessed them doing it, and you follow them. And you run, and they run into a house. What do you do? Because they were just smoking marijuana like outside. But now they've run into a house. Now we know that rarely exigency will exist for minor offenses, but it doesn't say never, right? Hot pursuit and public safety kind of get meshed together here, right? Where it could be the person's house, you don't know, you don't have time to check, but if that person goes in there and is holding somebody hostage, like you need to follow them. And I think we would all agree that if some person runs into our house, regardless of the underlying offense, we would rather have police come into the house to help us, right? So again, it's rarely, but not never. So that brings us to a couple of cases that are really interesting. Tennessee versus Gardner, this is a case that is very upsetting. And it's one that evokes what we see happening today in terms of the relationship between race and police, etc. So Tennessee versus Gardner, basically it was two cases that are consolidated. But what happens is Gardner, police respond to like a call, right? And it's a burglary call. They respond. They see this guy come running past, right? He starts to climb over a fence. Officers pull out their gun and shoot him in the back of the head, right? The officers admitted that this kind of figure that they saw didn't appear to be threatening, didn't have a firearm or anything along those lines. So Gardner's father sued, right, for unlawful use of force in making the, quote, arrest. Gardner dies from his injuries. And what police describe and what really happened were very different things. So police describe this guy as being like 6 foot tall, huge bulky guy that was pushing his way past people. I mean, just a big guy, right? So inherently threatening. That's great until you read the autopsy report, in which you find out that Gardner is a 15-year-old boy who is 5'10" and thin as a rod. Keeping in mind that police said they never saw a weapon or anything along those lines. So what happens is the question goes up to the Supreme Court, right, and holding that a killing of a fleeing suspect is a seizure under the Fourth Amendment, and would be reasonable only if the suspect posed a threat to safety of the officers or the community at large, right? So in other words, police can only use force or deadly force as necessary when the person poses a threat to public safety or the safety of the officers. In this case, he was running away, right? Did not turn and attack. They did not observe anything on him. He was climbing a fence for theoretically a nonviolent crime, and they shoot and kill him. And he was a black child. Supreme Court said no. That is what Gardner did was unconstitutional. Or excuse me, what the police did, excuse me, it was unconstitutional, and arresting, quote, killing Gardner, right? So again, we can only use force on fleeing felons. That's the big one, felons. When we have a reasonable belief that the felon poses a threat to the safety of police officers or to the community at large. So the question then becomes, how do we gauge reasonableness? Okay? And that takes us to Graham v. Connor. Basically, in this case, it's a really upsetting case. Graham was a diabetic, right? And he had an insulin reaction while doing work on his car at his home. He asked if his friend could drive him to a convenience store in order for him to purchase some orange juice to counter his reaction, right, needing the sugar. When they arrive at the store, the defendant in this case, or Graham, rapidly left the car. Right? He entered the store and saw a line of 4 or 5 people at the counter. Not wanting to wait in line because he's having a reaction, he quickly leaves the store and gets back in the car. Now the officer observes him entering and exiting the store quickly. So he follows them and he pulls them over about a half mile away. Now Graham is still suffering from an insulin reaction, right? And in so doing, he exited the car and ran around it twice, to the point that the driver of the car and the officer had to stop him running. Now they set him down on the curb, and he passes out. When he wakes up, he finds himself handcuffed, laying face down on the sidewalk. And there are several more officers around him at this time. The officers pick him up, still handcuffed, and place him on the hood of the vehicle. Graham basically attempts to reach for his wallet to show his diabetic identification card. And an officer shoves his head down onto the hood of the vehicle and tells him to shut up. The police then struggle to place Graham in a squad car over Graham's vigorous resistance. Officers soon discover that Graham had not committed a crime at the convenience store, so they return him to his home. The problem was that Graham sustained multiple injuries, including a broken foot, as a result of the police officer's actions. So the court was unanimous in their decision, right? And they said that claims of excessive force used by the government are properly analyzed under the Fourth Amendment objective reasonableness standard, right? So how do we judge if something is reasonable or not? We say, is it objectively reasonable, not subjectively reasonable? So not, was the officer reasonable in their belief, or would a reasonable person in the same situation have done the same thing, right? Would they have said, yes, that seems reasonable given the context, right? So use of force really determines and really relies upon reasonableness. And then looking at one last case, we have Scott v. Harris. Scott v. Harris is a 2007 case involving high-speed pursuits, right? So basically, a police officer attempted to pull Harris over. Harris fled in the vehicle and started a high-speed chase. When the police tried to end the chase, they rammed his vehicle with their cruiser, with the police patrol car. As a result, Harris crashed and was rendered a quadriplegic. Harris sued in district court, alleging that the police officer had violated his Fourth Amendment right by using excessive force. Scott claimed, or the police officers claimed qualified immunity. You don't need to understand all that. So the question kind of becomes, does a police officer who stops a high-speed chase by ramming a fleeing suspect's car violate the Fourth Amendment's protection against an unreasonable seizure? The answer is no. The court ruled in an 8-1 decision that the police officer and the police officer's actions were reasonable under the Fourth Amendment. It relied heavily on video footage from the car, right? And in the car, it shows that he was Harris was driving very irresponsibly. He posed an actual and imminent threat to the lives of any pedestrian who might have been present, to other civilian motorists, and to the officers involved in the chase, right? And the opinion weighed the need to prevent the harm Harris could have caused against the high probability that Harris himself would be harmed by the officer's use of force. right? So they looked at culpability, they looked at the records, they looked at the video, and they said, okay, if you engage in a high-speed pursuit, trying to end it using a pit maneuver or ramming may be objectively reasonable. Again, a lot of it depends on, like, if it's an empty road and there's no other cars around, that might be different than if you're doing it through the middle of the city. But objectively, it was reasonable. That being said, a lot of police departments have gotten away from doing high-speed pursuits because high-speed pursuits never end well. Either the officers get hurt or killed, the suspect gets hurt or killed, or an innocent person gets hurt or killed. So especially in a city, if a car takes off, police officers might try to follow it for a little bit, but if it gets excessive speeds or recklessness, they'll call off the pursuit, right? Because the officers have the person's license plate, right? So you just send the detectives or the SWAT team out to get the person after they do investigation, right? Because there's no reason to put the public in jeopardy. Now, if this person is suspected of, like, mass murder, well, that's a little bit different, right? Than if the person had drugs in his car or whatever. But that being said, high-speed pursuits are reasonable as long as we have fact patterns similar to what we have in Scott v. Harris. So that being said, next lecture we'll talk about the introduction to interrogations.